evening, everyone. My name is Yaida Ford. Hope everybody can see me and hear me clearly. But I am your host for tonight's virtual town hall for federal sector employees, where we're going to be discussing all things trending in the world of the federal sector employee. Joining me tonight are two attorneys from the Washington, D.C. area, Peter Broida and Elaine Fitch. I'm going to start off by just reading snippets of their extensive bios, and then I'll get into our disclaimer for tonight. We should be streaming live on Facebook. For those of you who are joining us, welcome. And for those of you who are with us in the Zoom, welcome. Attorney Peter Broida is a federal civil service lawyer. He represents employees throughout the country. He also represents unions and federal agencies requiring specialized counsel. However, most of his representation is for individual employees. Peter, and these are my words, I'm not reading from his bio, he eats, sleeps, and drinks federal sector employment law. He has literally written treatises on the Merit Systems Protection Board, which you'll hear the acronym MSPB as the night goes on, and we're referring to the Merit Systems Protection Board. He's also written treatises on the Federal Labor Relations Authority. The acronym is FLRA. He's also written treatises on federal sector labor arbitration. He's presented innumerable classes and lectures on civil service law, and he is just a dynamic lawyer, and I'm very honored that he's with us tonight. Also joining us is Elaine Fitch. She is the managing partner at KCNF, which is a firm here in Washington, D.C. They specialize in security clearance law and procedure, and she particularly works in that realm and the federal employee sector realm. So Elaine has extensive litigation experience before the EEOC and in federal court. She does all types of employee litigation, including discrimination, harassment, and federal disciplinary matters. I've had the privilege of hearing her speak before today on issues that pertain to federal sector employees and the different executive orders coming out. And she's just coming back from Africa, so I'm very pleased that she found the time to be here tonight while she's catching up on what I'm sure is a very hectic and chaotic docket. So that said, we only have an hour, and I promised these lawyers I would get them out on time. And so I'm going to start and kick this off with our first question. Now, I want to say this for the record, that we are not giving individualized legal advice. That's not what this is. We are just going to provide you with some information pertaining to federal sector issues. I should introduce myself a little bit more extensively. I was reading very long bios. My name is Yaida Ford. Again, I am the managing partner of a civil rights law firm here in Washington, D.C. I also represent federal employees, but not nearly as long as Peter and Elaine have, which is why I've asked them to join me, particularly as it pertains to federal sector work, administrative agency work. I am a trial lawyer, so I prefer the courtroom to agency litigation, but you got to start somewhere, and federal sector employees, generally speaking, start at the agency process. But we'll talk more about that. So my first question is for Elaine Fitch. By the way, folks, if you have questions, please use the Q&A. I will refer to that. If we have time, I'll be able to pull out some questions, but trust me, we've got you covered. We had a survey done, and people were able to send questions in advance. And so I'm sure we have all the topics covered, but feel free to use the Q&A at some point in time if you have a question. And if I have time, I'll get to it. The first question is for Elaine Fitch. Elaine, what legal considerations should federal workers consider if they are presented with an offer to accept the deferred resignation program, or an offer from the deferred resignation program?
So the DRP is obviously going to be unique to every individual. It's going to depend on your circumstances, what's happening with your family. But in my mind, the biggest consideration that anyone should contemplate is that when you sign that agreement, you are waiving your rights to file any kind of complaints against the government related to your employment. So if you have a pending EEO or MSPB case, if you're challenging any aspect of your employment, By taking the DRP and signing the agreement, you are waiving your rights to challenge that. I've seen various agreements. You can accept the DRP and they will eventually send you an agreement. Some of them are actually pretty well written. Others are very poorly written. I have yet to have an opportunity to challenge that with any of the agencies. Most of my clients have just said, you know what, I'm going to take it. It's fine. I want this over with. I did reach out to other people in the employment law community and asked if anyone else had had any luck changing any of the language. And either no one had or no one had tried. So I suspect that people are generally stuck with the language that is on the table. Things, not so much legal considerations, but obviously, you know, are you a probationary employee? How safe is your job? Are you likely to be riffed? Are you eligible for retirement? Is a VERA being offered as part of the package? Those are all factors to take into consideration. And I think the one other thing that I don't have the answer to necessarily at this point is there is one federal court case out there that is challenging the DRP and the legality of it. And I looked it up today. There's been nothing on it recently. That was the case up in Massachusetts. There was a TRO issued and then it was denied. So now it just seems to be pending whatever future action might happen. But it is conceivable that at some point the program could be declared illegal, and then that might open a whole can of worms that none of us know about.
Do we know what some of the arguments are that challenging the legality of the deferred resignation program?
I looked at it briefly today. I know they were claiming it's a violation of the APA. They're claiming that it's arbitrary and capricious. They're arguing that there's no authority to do this, that OPM is basically committing other federal agencies to actions that they have no authority to commit them to. There was also the argument, so the case was filed before this second round of DRP, and before we saw what was going to happen, and before we had at least a temporary budget in place. So of course there were arguments that there might not be any appropriations, or that there was no appropriations for this program. There might be a few more arguments, but those are the ones I remember at this point.
Okay, thank you very much, Elaine. My next question is for Attorney Peter Broida. Peter, when a federal employee wants to lodge a claim over their termination, if they were fired during their probationary period, what venues are available to them?
Well, the venue would be the Merit Systems Protection Board, which is granted jurisdiction over reductions in force, including those of probationary employees. So the massive layoff of probationers for poor performance was nothing more than a constructive reduction in force. So that's where they go. And ordinarily, probationers have little to no protection under union contracts. And what little protection they might have is probably now dissolved because of President Trump's executive order about a week and a half ago, essentially disenfranchising federal sector unions. Now, could a federal probationer or trial period employee go to the Office of Special Counsel and complain of, I'm not sure what prohibited personnel practice. I know what the Special Counsel conjured up in their request for a stay to the MSPB. Basically, it was a constructive reduction in force theory. They could, but there's no special counsel because the special counsel was fired and chose not to litigate the dismissal. And without a special counsel, I can't see how the Office of Special Counsel is going to be asking for any stays or corrective actions. So your venue is the MSPB and not courts. The rule generally is if there's an administrative agency that's designated by law for your problem, you don't bypass that and go running into federal court asking some district court to give you the remedy that the administrative agency may be able to give you.
So what Peter is referring to, everyone, is something called administrative exhaustion. Federal worker who we're just talking about now probationary employees, but generally employees who work for federal agencies have to administratively exhaust their claim before they can just go to court. And so administrative exhaustion is a requirement, and without that, the claim can't proceed.
Let me add. You can always file an EEO complaint, but I don't think it's going to get you anywhere. Proving discriminatory animus in these massive terminations, I think, is going to be very difficult, and you end up with more complications because it becomes what's described as a mixed case appeal, which might ultimately be able to be taken to the Merit Systems Protection Board. But all that you're doing here is adding a level of unnecessary complexity. So if you want to appeal, go on to the electronic filing system, the MSP, go file your appeal. It'll join thousands of others, and someday it'll be adjudicated.
Well, and that was my next question, what is the process for filing a claim with the MSPB? There is an online process for that, correct?
Yeah, there is, and I've seen some of these agency RIF notices that suggest that you file a paper appeal. I laugh because some of these notices are so poorly constructed. I think my pet cat could do better. So the point being that the MSPB on their website has an e-filing option. The electronic filing system is slow. It's getting slower. Plan to spend about half an hour of your life filing the appeal. You will need, when you file the appeal, to have a copy, a PDF of the RIF notice. That will be requested by the e-filing system. So have that available so that you can upload it to the board system. And all these RIF notices are correctly stating the appeal rights, the ones that I've seen. And they'll have information about the MSPB. You have to file your appeal if you get a RIF notice, either starting from the point of the decision to RIF you, which might be today, and not later than 30 days after the effective date of the RIF, which might be early June. And those are calendar days. The MSPB is very unforgiving of delay. So file on time and worry about getting a lawyer or paperwork or who knows what later. Just get the darn thing filed, and it'll take on a life of its own.
No, for the MSPB process, what are the possible outcomes for somebody who has filed their claim with MSPB, and what are the outcomes there in that agency or with that venue, that tribunal?
Is that directed to me?
Yes.
Okay. I want to stay within the rails here. Sure. All right. So, at the MSPB, you win, lose, or settle. So if you win the RIF appeal, hooray, you go back to work. Maybe, assuming there's an agency to go back to. If you lose it, you can file what's called a petition for review from the decision of the administrative judge, who receives and adjudicates the board appeal when it's first filed, and it will be directed to a regional office. The regional office probably closest to where you work, and there are regional offices in Atlanta and Philadelphia, San Francisco, Chicago, and what have I left out? Oh yes, Washington, Denver. I'm sure I've left out one, but the system sends it to the right place. So you can file a petition for review, but probably the way a lot of these cases are going to go, I think, is probably settlement. I think what's going to happen here is that the agencies, after these RIF appeals are filed, are going to take chunks of money and decide they're available to pay people, in addition to whatever severance pay they've received, a lump sum, which may or may not, as a practical matter, be negotiable. And they'll say, here is $20,000. Here's $25,000. Why don't you take this and go away? And I think some people are going to say, sounds good to me, and away they go. So the case will be settled, and there it ends. All this, of course, at taxpayer expense. Uh, so I do believe funds would be made available for settlement. Now, federal employees, I've learned over a long time, are people who have certain beliefs and entitlements. Uh, I used to represent private sector employees, and their thinking is not quite the same as the federal employee who is 50 years old and is thinking, well, I would have worked till I was 72. And what I want to have is the salary difference between 50 and 72 plus all the retirement contributions. What about my thrift plan? And that will come to $3.7 million plus interest. Well, that's not going to work. That just doesn't work. So set aside the entitlements and be prepared for what I think will be lump sum settlement offers, which won't be huge, but they'll be enough to pay the mortgage for a while.
Peter, sorry to jump in. Do you think they'll do that for the big class RIF cases?
The class rifts, I don't know what they're going to do with that, Elaine. The board does not traditionally handle class actions.
But they have a lot of them now.
Well, they have a lot of them filed. Have any been certified? They have.
Not that I'm aware of yet.
Yeah, I don't think they're going to be certified. I think based on board past practice, they'll consolidate cases, but not certify them as class. And the difference between class actions and a class action, you have Manny, Mo, and Jack who are representing 1,000 people. You have class representatives, and then you have counsel who theoretically can handle the complexity of cases that involve a lot of people. It's a lot of administrative effort. The consolidated cases, they take everybody who, say, is within a competitive area who appeals from the National Institutes of Health and put them all together in one large group. And if they have counsel, each counsel representing each person is involved in the case. It's rather duplicative. And if they don't have counsel, fine. But it's done on a group of people, not class representatives. So we shall see. And lawyers file these class actions because they think they're kind of neat and fun. And they'll represent lots of people by having a few named representatives. The board does not, I don't think, find them so neat and fun because the cases are being handled by these administrative judges who are GS-15s. They're not used to class action litigation. They don't have enormous amounts of time to administer these cases. All these judges will have other cases, 50, 60, 100 nowadays. These cases are being filed at the rate of 1,000, 2,000 a week. And these judges are not, in my estimation, particularly interested in becoming specialists in class action administration. So I don't know, Elaine, how this is going to work out. But traditionally, the approach has been, for example, with termination of bunches of air traffic controllers back in the day who got fired. They were consolidated regionally, not class actions. There had only been a couple class actions in board history, and they've not been involved in cases like this, much different types of cases.
Well, you all kind of got into my next question about class action lawsuits. And so I want to kind of distinguish what you're talking about, Peter, with consolidated matters and class actions. So with the class action lawsuits, and there was a lot said in the last 2 minutes, so I want to kind of break that down regarding class action. So there are lawyers who are working up class action cases. By my count, as of today, there are about 20 different class action lawsuits that have been filed challenging federal sector terminations. So this question is for you, Elaine. Why are there so many class actions being filed on behalf of federal workers? Why are there so many?
So are you referring to cases in federal court or before the OSC or the MSPB or just all over the place?
I guess we could break it down. Let's start with, and we can explain just for the sake of the audience, why some are filed before the board or MSPB and why some are filed in federal court. So let's start with federal court. That's my favorite.
So there are a lot of cases in federal court. I think you're looking at different parties bringing the cases. So you have unions bringing some of the cases. You have the states have brought some cases, even addressing probationary employee issues. Some of the lawsuits are specific to particular agencies. For instance, USAID, I think there's at least one suit. And in that one in particular, they're challenging the termination of probationary employees. So in thinking about, well, I know you wanted to stick with federal court, but those I think are a little bit more limited. But for instance, James and Hoffman's, and there's a group of attorneys that have filed class cases on behalf of probationary employees at the MSPB. And those are filed by agency.
Okay. So one of the reasons why there's so many is because they're filed by agency. And so if I'm a federal employee and I want to sign up for a potential class action, I should look for the class action that involves my agency. Is that right?
Yes, but you don't usually have to sign up for a class action. Class actions are typically opt out. So you will be included in it unless you choose not to.
Now, Peter mentioned something, and sorry to cut you off, but Peter mentioned something about whether or not, he asked you whether or not anything has been certified. So let's explain what that means. That class actions, have to be certified at some point. So can you explain the significance of that?
So when you file your appeal with the board, you also have to file a request to certify the class, and you have to establish that the named class appellants at the MSPB, it's typicality, numerosity. Yeah. Somebody might need to help me out on the last two, but they have to be appropriate representatives for the class. And it has to be that that those individuals have enough in common with everybody else that essentially the issues can be treated as one. And if they decide to certify, then the case will go forward. And if they decide not to certify, then everybody has 30 days. Everybody who's a putative class member, meaning they would have been a class member if it was certified, they then have 30 days to file their own appeal with the MSPB.
And so, thank you for that, Elaine. So we don't know, and Peter mentioned that he didn't think anything was going to be certified, but was it that nothing has been certified yet?
As far as I know, nothing has been certified. I don't know that I agree with Peter on that point. I think that the board will be so eager to try to group these cases together. I know they are consolidating some of the individual cases, like a bunch of the people who are illegally fired under this Article 2 nonsense. Those are all being consolidated because they were filed by individuals. But I remain more optimistic that the board, despite its lack of experience with class actions, will see this as a means to address the bigger issue for a lot of people at once.
Well, I think this is, at least I know I, for one, didn't know that a class action could proceed in front of the board. So this is definitely news to me. Let me shift gears a little bit. Actually, before I do, let's talk about the difference between a class action and a consolidated case. Can one of you explain the difference? Maybe Elaine, can you take that one?
Peter might actually be better suited to that. I haven't dealt with a lot of consolidation before the board. I know they did that with the furloughs and whichever, what was that, 18, 19?
So Peter, can you explain and you were the one to raise this. So what is the difference between a class action and a consolidated case?
All right, fine. The class action involves one or two or three or four or five or six representative plaintiffs or complainants or appellants in the board. It would be called appellants. And they claim to represent the interest not only of themselves, but of a much larger group to whom the same action has been directed, say probationary termination. So let's say at the, you take your pick, Department of Agriculture, doesn't really matter, 500 probationers got termination notices. A lawyer is contacted by one of them or two of them or three of them and says, gee, I think I'll file a class action, takes the three, calls them representative plaintiffs, appellants, and goes to the board and said, I've got these three appellants who represent 500 people similarly situated, and I want you, the board, to decide the lawfulness of the probationary termination for not only the named appellants, but everybody else who's similarly situated. And the board says, whoa, how are we going to administer this? District courts are able to administer class actions. They have larger staffs, they have magistrate judges, they have special masters, they do other stuff. The board doesn't have this. This is why I'm not so sure the board's going to do this. It's a lot of work. The other approach is just everybody files an appeal, let's say from the Department of Agriculture, who's distressed about the probationary termination, who knows about the MSPB, and takes the time to file the appeal. And then the judge says, I have 37 appeals here from people at, say, the Department of Agriculture who got fired and who have filed their cases with, let's say, the Washington office or the Philadelphia office, the Northeastern office. I'm going to take all these appeals and we're going to start with the letter A and we're going to go to B and we're going to end up with the Z's. And it's going to be one big case with these 37 people, every darn person listed on the case. And then the judge says, all right, people, this is going to be handled as a consolidated case. And if someone there doesn't want to be in the consolidation for some reason or another, they can ask to be handled on an individual basis, and the judge would decide whether to do that. That's the difference. It's a smaller group representing a much larger group, or a larger group with every single person listed. That's the consolidation.
And given some of the, I want to come back to this. I'm tempted to stay on it, but I want to come back to this because I want to ask this question. But I guess relatedly, does it make more sense? One of the questions that I have is that certain labor boards are short-staffed right now. I'm hearing a lot of talk about that, and we know even today the Supreme Court ruled on the reinstatement of certain. I guess there are two board members, if you will, that Trump fired, and they were temporarily reinstated, and then the Supreme Court halted those reinstatements. And so there's a lot of talk about whether or not some of these labor boards that would literally be arbitrating these disputes, whether or not they have the staff to do it. And so, Peter, is the consolidated piece, is that more attractive for somebody who's signing up? I mean, what should they expect what's the wait time? If I'm filing by myself as an individual, and I don't know anything about the consolidated stuff or the class actions, like what type of delay should I expect?
I don't know. The MSPB is, really, what can I say? The MSPB is never quick, particularly with complicated cases, whistleblower cases, cases of disability discrimination that enters as a affirmative defense. They're not quick. And if there are lawyers involved, it slows down enormously because the lawyers fight amongst themselves in a civil way, I hope, but it does increase the time. So ordinarily, the board's desired adjudication time is 120 days, 4 months from the time the appeal is filed. Does that happen? Yeah, it happens in cases that can be immediately dismissed because they're untimely or they're not within the board's jurisdiction. But any case of complexity is going to go beyond that. Now, there are two levels at the board. You have the administrative judges. There are about 60 of them or so spread out through these various regional offices. And these people they're careerists. They just do their job day in and day out. And the number of them doesn't change much. A couple of them have retired recently, and there's a hiring freeze. So they're down a few judges. So the judges just do what they're normally doing. The problem is that their caseload is probably quadrupling and they can only do so much. These judges are civil servants. They work a civil servant day and a week, and they go home and they do other things. So they only can do so much. They're not like Elaine, who operates a law firm where all the partners there work 23 hours a day. It doesn't work that way, not with the board. So then there's a second level of the board, which is where the review requests go from the initial decisions, as they're called, that are issued by the judges. So there, the process is slow as well. If there were no other complications, the average time probably to adjudicate the petition for review that goes to the board might be 8, 9 months, maybe a year, maybe a little less. But now the darn board is operating not with the 3 members that it's supposed to have most of the time, but it used to be up until a few weeks ago just with 2 members. One of the members happens to have been the prior special counsel, one of whose responsibility was to deal with whistleblower cases. So every time a darn whistleblower case comes to the board, he has to recuse. And then we have left this one member, Ms. Harris, who was fired by President Trump, put back in place by a district court, taken out by a appellate court, put back by a en banc review by an appellate court, and today taken out by the Supreme Court for at least a while, until I don't know what happens next, whether the Supreme Court does something or whether the DC Circuit does something further. I'm just not tied into the litigation process there. But the answer to the question is, how long is this going to take? It could take a very long time, because the board will get these petitions for review and they're all going to back up. And then the board will usually take them on a first in, first out basis. This is exactly what happened when the board was out of business from 2017 January to March of 2022, when the board lacked a quorum and couldn't issue any decisions. So they ended up with about, I forget how many it was, 3,000, 4,000 pending petitions for review. And Ms. Harris, for whatever Mr. Trump may think about Ms. Harris, was successful in leading her little organization to diminish that backlog as new cases were coming in to 600 or 700 or 800, which still sounds like a lot, but it was a very respectable drop. But now this is going to happen again. What was your question? How long is this going to take? I have no idea.
Well, yeah, I mean, but you said, let's just break this down. So basically, folks, the MSPB process could take a long time. One of the board members who he's mentioning, Kathy Harris, was fired by President Trump. She was a Biden appointee. There was a backlog of about, I don't know how many thousands he mentioned, 3,000 or 4,000. She got that backlog down to 600. Trump fired her, but he had to do it for cause. And that's not what happened. So she was reinstated by a trial judge here, Rudy Contreras, who I've appeared in front of. And then obviously that reinstatement was flipped. And then she asked for an en banc review. It got flipped back. And then today the US Supreme Court said, they halted her reinstatement for the time being. And so this is affecting what Peter is saying here. It's affecting the trajectory potentially of a claim. But that, not to discourage folks, there is light at the end of the tunnel, but perhaps a consolidated case, if you are eligible, or a class action might be, you might be eligible for that. And I will send the link out to those who registered for the event through Eventbrite. We will make sure that we will email you the links to the class action list, so that you can check that out. If you work for one of the agencies, there's a consolidated list, and there's a link. And so I will happy to send that out to all the registrants for you to utilize at your disposal. Now,
Yaida, can I jump in for 1 second?
Yes, please.
I just want to make sure people understand that even when there's no quorum at the board, the underlying cases will still be processed. The judges are still working, hearings are still being held. Where it gets hung up is if either side files a petition for review. But there is also the option that if the appellant loses, they don't necessarily have to go before the board. They can take the case into federal court. So there are some ways. If, of course, if the appellant wins before the judge, and the agency will undoubtedly then file a petition for review where it will be stuck.
Yeah.
Assuming Kathy is not reinstated.
Yes. Yeah. No, thank you, Elaine, for that. So let's, on the issue of reinstatements, and then there are a couple questions from Q&A. I want to take a couple of those. Yesterday, the Supreme Court ruled that the reinstatement of about 16,000 federal workers had to be stopped across several agencies. That's USDA, Energy, Interior, and some others. What will this mean for affected employees? So there are likely people here in the audience who were reinstated by a court order. And they don't know what their fate is, right? So can you explain what this means when you're reinstated and then you're not?
So what I am assuming they will do is that they will be fired. The government will fire them again. So there were 4 federal court cases pending challenging the terminations of probationary employees, and TROs were granted, and then they were denied. They've gone up on appeal. The courts are moving very quickly on all of this, teeing it up for the Supreme Court. But right now, there was a decision yesterday where the TRO was denied, as you were mentioning. So the
TRO was a temporary restraining order, everyone.
Yep, sorry about that. So there was oral argument in one of the cases today. I think that was the case, that only had to do with the CFPB. So I don't know what the outcome of that is going to be, but the other ones at this point, there's no injunctive relief, and so there is no basis, there's no reason why the government has to keep most of these probationary employees. Now there is one set, the OSC before Hampton Dellinger was terminated and then decided not to pursue his case. He did request a stay from the MSPB for 5,000 USDA probationary employees, and that was that MSPB issued that stay of their termination, and that is in effect until, I believe, April 18th.
So those particular USDA employees, so everybody's clear, those 5,000, they were reinstated, and they're still reinstated until April the 18th.
Yes, if we still had Hampton Dellinger in place, I'm certain that another stay would be requested, but the special counsel has to request the stay from the board. The board can't issue it without the request. And right now, I think Doug Collins is the acting special counsel, and he is also the head of the VA and a very well-known Trump supporter. So I do not anticipate that he will be requesting any further stays of the terminations.
Okay, so the process has been somewhat politicized for federal workers to kind of help the president accomplish his agenda of reducing the size of the government. I'm going to quickly turn to one of the questions in the chat. I'm doing it off memory because I cannot see, or it's a Q&A, sorry. This might be for Elaine. So Elaine, apparently, I don't know, if Congress has not approved funding for the DRP, is it a binding agreement, or is that a legal argument that's being made?
Well, I think that's just an argument that's being made. If you think about this, they're essentially just agreeing to pay people their wages through the end of September. And so, I mean, I think that it's a fair argument to make that they don't necessarily need a separate appropriation for that. The money has already been appropriated for wages and salaries. So I don't know whether that would be a successful argument or not.
Okay, thank you for that. And then one more question, and this is about, this is related to the DRP, the reduction in the deferred resignation program. For those that might find themselves a new job while they're on administrative leave, are they still eligible for any future litigation? And if in fact they have accepted, if they're on administrative leave for whatever reason, pursuant to an executive order or whatever, and they get a new job and they take it, I assume that's what that question is asking, are they then eligible for possible future litigation, perhaps?
All right, I'm sorry, what was it that the last 7 words, are they eligible for what?
Future litigation. So if somebody is put on administrative leave pursuant to an executive order, they find a new job and they take the new job, are they excluded from any future litigation over their acceptance of the buyout or the deferred resignation program or something similar?
Right. Is this the question assumes that they've entered into the resignation program?
The question is, it assumes that they are on it. They've been placed on administrative leave and they've decided to walk away from that and get another job. Are they still eligible for any?
Well, okay, so they're on administrative leave, they resign.
Mm-hmm.
Is this what you're talking about?
I think that's what it would be. Is would be a resignation. Yeah.
Right, and you go off and work for the corner grocery store. Well, could you resign and then appeal that?
Yeah.
Is that the question?
Or could they sign up for a class action suit? Not sign up, because I guess you opt out of it. But would that make them ineligible for something or for some pursuit of their rights later if they walk away?
The presumption is that if you resign a job that is voluntary and you don't have any appeal rights. All right. Now, then, of course, there are exceptions to that. If you resign a job because of misleading information, if you resign a job because the supervisor is holding a gun to your head, if you resign a job and you're incapable of understanding what you're doing. So there are exceptions, but the exceptions are hard to prove. So if you walk away from your federal job, say bye-bye, I'm going to take another job. You can always, anybody can appeal anything to the board. That doesn't mean it stays there very long. So a judge would send out a order saying, hi there, friend, you've appealed from what is presumed to be a voluntary act, and you need to tell the MSPB why it's involuntary. I don't know if this answers the question or not, but it's the best I can do.
No, I think that's fair. And I gotta see another question, and I'm gonna say the answer to this is no, but I'm gonna ask Elaine and Peter. I've never heard of anyone paying a lawyer to be a part of a class action suit. Now, I've only seen a few class action lawsuits in my areas of practice. Is it normal to pay a retainer to be a part of a class action lawsuit where you're essentially opting out of it if you're not a member of a class? How does that work?
Is it normal? No, I would not say it's normal. I do know that there are some law firms out there that are asking for retainers and retainer fees for people to become part of a class. But typically class actions and class action firms don't require retainers.
Okay, thank you for that. And let's see, we've got a few more minutes. You all, I want to shift the conversation a little bit to DEI. I feel like of all the executive orders I'm hearing, I don't know, I don't want to say I'm hearing the least about this. I guess it depends on what's in your feed, in your Google feed that day. But I think I'm the most confused about this, the DEI stuff, more than the other stuff. So, okay. The White House issued this executive order eliminating DEI initiatives. We don't know what that means. There was a federal judge in Maryland who was like, yeah, this is vague. We really don't know what you mean by DEI initiatives, or some of the terms were just very vague in the executive order. So agencies arguably agencies don't know how to enforce it. Does eliminating DEI initiatives mean shutting down the EEOC offices within the agency? EEOC meaning the portion of the agency where a federal worker would go to file a claim of discrimination, which most federal employees are familiar with the EEOC much more than the MSPB or some of the other agencies that we've discussed. So has there been an adverse impact on EEOC offices within the federal government because of the White House's executive order basically banning DEI for the next 4 years?
We have seen some federal agencies fire their entire civil rights office, which includes their EEO office. Not all of them are doing that, so it is unclear who's deciding what. it doesn't make any sense because a lot of the EEO positions are statutory. They're required to have them, but they appear to be pulling people from other jobs and giving them EEO duties as collateral duties. Like I said, we haven't seen that everywhere. But my firm is actually working with Leif Cabraser, the ACLU of DC, and Democracy Forward to represent federal employees who have been placed on admin leave and or who are being terminated because of either their DEI duties. Some people were placed on admin leave because they'd attended a DEI training. It's incredibly tangential sometimes, the relationship that DEI has to particular employees. But this group is working together across all the federal agencies to put together a class and get people first through the administrative process and then hopefully take it into federal court.
Okay, and I have a related question to this. Somebody put this in the Q&A. If an agency conducts a reduction in force that targets a very small branch within the agency, that may include, for example, underrepresented scientists, and I'm not sure what underrepresented means, but could this potentially be considered an EEO matter, in your opinion? I would think that depends on the whether or not that group of underrepresented scientists has a protected characteristic that's covered by the statute, like, age, gender, race, sexual orientation, etc. But please, one of you can hop in on that question.
Well, you could always, sure, you file an MSPB appeal from the RIF, and one of the bases for setting aside a RIF would be discrimination, or that it was motivated by personal characteristics. I just didn't like Peter, the lawyer, so we're going to have a competitive area of one, Peter, the lawyer, and we're going to RIF him. If it's based on personal characteristics, and certainly characteristics that are preserved by the civil rights laws, that becomes an affirmative defense and a ground to set aside the RIF. Now, it's one thing to allege it, it's another thing to prove it. And you're going to need a lot of evidence to convince the MSPB that a RIF of a group of people was motivated in some fashion by discriminatory animus, or have a large enough statistical base to prove some type of disparate impact. The board does not often find discrimination with respect to anything other than disability. And back in the day when there were some RIF cases decided by the board, they certainly did have a couple cases that involved allegations of discrimination, but I'm not so sure that they were successful, but they were certainly litigated. So it's litigable. Whether it's winnable is something else.
Yeah. Well, another question here related to RIFs. We've talked a lot about the, I guess, notices of deferred resignation or whatever, but for individuals who were RIFed, got reductions in force, and they were asked to sign a RIF notice. On some of the notices, apparently employees are saying that they're being asked to sign an acknowledgement of receipt. And on some notices, they're being asked to sign an authorization for release of information. Some employees have concerns about acknowledging receipt or being asked to sign an authorization to release information, because why? So is it, I mean, the question is, should or should not, what should employees be concerned about? They're asking, should they sign them? And we can't really advise them, but is there anything to be concerned about when an employee is asked to sign acknowledgement of receipt or an authorization to release information? That seems really odd to me. I, for one, have never seen a notice like that.
No, it's signing for receipt of a document is not unusual. For example, if a person is presented a proposal to fire them, or the person is presented a decision to fire them, it's not unusual to ask the person to acknowledge receipt. They can do it, they don't do it, it really doesn't matter. They're not agreeing with the action, they're just saying they got the paperwork. It's like certified mail. Ditto the RIF notices. They want to know that you got it, fine, you got it. It's not, you're not going to win the case because You didn't sign the thing, and the agency's not going to be able to avoid showing if you contest it that you got the RIF notice because they're going to have the email trail, right? Yeah. So, and anyway, they'd have discovery and you'd have to state whether you got it or not. So I don't see a problem with asking for an acknowledgement. Now, this information disclosure I haven't seen before. And when somebody read it to me today, I still don't understand what they want or why they want it. So I suspect that some 17-year-old intern developed this and now it's being used government wide, but I have no idea what it means.
Yeah, that's what I was referring to. And I said, I've never seen that before.
Yeah.
Do we think that's like a Doge, like um, authorization
I'm
of
telling people
information
not to sign it.
Hmm?
I'm telling people not to sign that. It is the way it is worded is so obtuse. Why would anybody release anything to these folks?
Yeah.
Yeah. Yeah. You get emails from them. Terrible. Oh, you don't want that. No, I don't see, since I couldn't understand what they were doing with the information or what information they wanted, I
Right.
couldn't see any good reason to have people agree to it. I don't get it. So anyway, somebody might explain it someday, and then I'll say, "Oh, I understand." Okay, haven't seen the explanation.
Yeah. No, you understand better by and by sometimes, or hindsight is 2020, as they say. So we are now in the last 10 minutes of our session. So time flies when you're having fun. But I wanted to ask, I guess I'll start with Elaine. Are there any particular cases? There's so much information out here right now, and then some of it is misinformation. But are there any particular cases that you think federal workers should keep their eyes on?
Well, there is actually a website. Let me see if I can find it. If not, I'll get it to you later. There is a website, Liberty. Oh, maybe it's not Liberty. Sorry, I'll have to get it to you later. But they are literally following every lawsuit that is filed out there. And so when I need to get refreshed on what's happening in a particular case, that's where I go. And you can click on the link. It takes you to the docket. So, and they've got it broken out by headers. They even have all of the immigration cases there, but all of the employment by USAID, by CFPB. They're not all broken down by probationary, but you can search it. So it really depends on what is your particular issue. But there, with the probationary employees, there are 4 separate cases that I would be following, and they're all listed there. And then James and Hoffman, their website, they don't update it frequently enough for my satisfaction. I think it was last updated mid-March, where they've listed all of the agencies. They've listed all of the agencies that they've filed. So I don't know if they filed others, but that's a good source of information.
That's the list of the 20 class action lawsuits that I was referring to, everyone, and that we will email that out along with the link from Elaine. We will get that to all of the registered participants to be sure. So I want to get into some of your personal experiences now with what you're seeing come across your plate as far as current representation. Are you getting more of the deferred resignation issues coming across your plate with individual representation? What types of representation are you offering to clients right now in the federal sector as it relates to the executive orders?
Well, lots of RIF. There's a lot of RIF issues out there, the illegal terminations, as I mentioned, under Article 2. At one point we were getting, when the RIF notices first came out, we were getting a lot of questions from people because the information included in the RIF notices was inaccurate. So questions about whether the competitive area was defined properly. I think everything goes in waves. Like every time there's a new executive order or some agency takes some action, then you get calls from all of those folks. But really right now, we're seeing a lot of RIF questions.
What is Article 2? Can you explain that for the audience?
No, not really. And I'm going to let the government try to explain it. Certain people, we talked about Kathy Harris, but if you're talking about like a career SES, they are entitled to due process and can only be fired for certain reasons.
Yes.
But the government came in pretty early and just handed them pieces of paper and said, I'm firing you pursuant to the president's Article 2 powers. And that was it. We have yet to see them offer a legitimate legal argument for this. So I'm going to hold my tongue until they figure out how they are going to argue it.
Yeah, no, that's good. Thank you for explaining that, Elaine. So Peter, what about you? What types of representation are you offering to individuals right now who find themselves in the throes of all the chaos of the federal workplace right now?
Elaine got it absolutely correct. It comes in waves. The president does something with an executive order. We get 50 calls. They're all the same. I got fired. All right. And they all got fired for the same reason. All the probationers get wiped out. Okay. And, so a couple of people wanted to retain me to appeal those as constructive reductions in force. Fine. I did that. The federal employees are very savvy. They talk amongst themselves and they talk to lawyers, particularly those unlike me who offer free consultations, and they get all this information, and then they file their own appeals, and that's fine. I don't encourage people to hire lawyers at retainers and hourly rates that I think would be astronomical if I had to pay them. If they can do this stuff for themselves, that's terrific. And now the second wave is the reductions in force. So I normally will have a consultation with somebody. And the way the consultation goes is something like this. Sit back, relax, don't appeal now, wait until the RIF is effective and see if the darn thing goes away, gets modified, or you get a nice offer from the agency in the meantime. And then if you must appeal, appeal. And if you really feel you need to get counsel, go hire Elaine. I mean, that's essentially what I tell people because I don't have the time to represent all these characters. I'm just by myself. The other thing I do is represent unions. And the unions right now are in the process of being disestablished. And I don't mean that figuratively. Their ability to collect dues, which is how they support their headquarters staff and infrastructure, has been wiped out by President Trump. And they can't file grievances or pursue them or get arbitration awards meaningfully reviewed by the Federal Labor Relations Authority. So a certain amount of my time now is dealing with my institutional clients, the unions. So, that's how I spend my time.
Oh, thank you, Peter. And Peter, what a sense of humor. I could, well, just sending people to Elaine. Well, so Elaine, she managed somehow to sneak away to Africa for a minute and then come back to all these referrals from Peter. So you all, thank you all for joining us. There's only 2 minutes left, so I wanted to emphasize that I will be sending emails to all the registrants. And then also you can follow me on social media for more updates and reels on what's happening in the federal sector workplace. I want to thank my panelists, Elaine Fitch and Peter Broida, for taking time this Wednesday night to be here. They probably will still be at their offices after we depart from this virtual platform. So thank you all. Oh, yes, my social media handle is Yaida Ford. It is my first and last name on Instagram. It's all one word. Please follow me and you will get updates on the different executive orders and all things civil rights and employment law related. So thank you all for joining us. God bless you and good night.